Good morning, Madam President, Your Honors. It is the same lineup as previous days. I will go no further than that in French. The presiding judge, thank you very much. We can now move on to the defense and their submissions on the merits. Mr. Kaufman, you may address the court.
Now, before I start, I would like to make one general comment, and it's a comment which every defense counsel who appears before this court is obliged to make. So if the mainstream media in the Philippines and the NGOs reporting on his case today report anything about the defense's submissions, I hope that they will at least communicate the following faithfully. The defense does not disrespect the soul of any deceased person, nor does it make light of the loss of life. Any criticism made by us today will not be leveled at the loved ones of those such as the tearful relative who I saw in the gallery here on Tuesday. The defense's criticism will be confined only to the prosecution's document containing the charges, which governs these proceedings, not what has been reported elsewhere in the media. It's not the defense's role to give an alternative narrative, nor to give an explanation for the facts and figures presented by the prosecution. The defense's role is simply to persuade your honors that Mr. Rodrigo Duterte should not remain in detention for years to come, simply because the prosecution cannot make out substantial grounds to believe that this individual committed the crimes with which he is charged. Now, Mr. Julian Nichols confidently said the other day that you can ignore Rodrigo Duterte's speeches. Disregard every speech ever made by Mr. Duterte, he said. Throw them all out. There is still ample evidence of the substantial grounds based on the other evidence. That's transcript T4, page 45, lines 5 to 6. Helpful advice from no less than the day-to-day prosecutor in charge of this case, because we will show that the evidence is not substantial, rather totally inadequate. But in any event, since I can leave no stone unturned, I now turn to those speeches. Now, if there's one thing that I've learned from the domestic media coverage of this case, it is that journalists and their editors have a tendency to fixate on the salacious elements of a person's speeches while ignoring the less interesting parts. And so it was with Rodrigo Duterte. The prosecution has had its opportunity to show you a selection of these speeches and seems to believe that the more they show, the greater the chances of convincing your honors to confirm the charges. But what the prosecution has not told the public is that in its document containing the charges, which governs these proceedings and nothing else, it has only supplied 20 of these speeches as proof of criminal intent. And as I mentioned in my opening statement, 10 of these speeches, including 2 referred to by the deputy prosecutor, actually contain an exhortation to the use of lawful self-defense. Thereafter, we found a further 35 speeches, which will be found at tab 9, 11 to 26, 29 to 35, 37 to 41, 43 to 46, 137, and 152. Now, this is obviously not a competition. The point we really merely wish to make is that relying on the former prosecutor's speeches as a means of proving criminal intent is impossible. Now, I'd like to go back to that one speech which I promised the other day to show you. This is a speech, the second speech that the deputy prosecutor referred to in his opening statement. And this refers to the responsibility that Mr. Duterte said that he would shoulder, promising to shield rogue officers from prosecution. If we may, the first of these speeches, and I quote what the deputy prosecutor read from this speech. So the police is under the DILG. So I have to believe the story of the police, for simply, they are my subordinates, and I am ultimately responsible for their deeds. Now let's look at what the Deputy Prosecutor didn't state from the same speech. And the order is simply this: go out, arrest them if you can, but if there is no peaceful method of doing it and you are presented with violent resistance, thereby placing your jeopardy in your life, you shoot, well, the son of the bitch. Mr. Duterte's language, obviously, but nevertheless an exhortation to lawful self-defense. Let's have a look at another one of the prosecution's speeches mentioned in their pre-confirmation brief. Once again, on shielding criminal agents from prosecution. I quote, this is, I apologize, PHL OTP 00001127 at page 5. And I quote, "But if you do your duty, do not worry about cases. I'll protect you. Believe me. That's why I will protect them. And if there's somebody who will go to jail, it's me. I will assume full legal responsibility." Now let's have a look at the exonerating element, which comes right underneath the allegedly incriminating element. He said, "Just do it right. We have our trainings that you can only kill if your life is in danger, and you are there performing the duty of a law enforcer. That's about it." Now I will turn to one of our speeches that we found in our research, one of the 35 that the prosecution didn't find. And I will terminate there because we have the rest, which we've referred you to in the tabs. So this is an exonerating speech which the prosecution either missed or ignored because it doesn't suit its case. And it was a speech which was made right at the start of the presidency, which could be seen as setting out the standard for his presidency. Mr. Duterte said this: "I promised them I will suppress crime and take control of the drug situation, which was really running wild in our country today. Make no mistake about it. I repeat again for all and for everybody's consumption. Do not kill if you are not in danger of losing your life." Well, it goes on. You can see it there on the screen. Well, of course, the prosecution knows that we are going to argue that many of these speeches, in fact, the majority of these speeches, I would say, contain this exhortation to the lawful use of self-defense. And the learned counsel, Mr. Edward Jeremy, for the prosecution, tried to get around the problem by inventing the novel concept of the elastic mouth, which out of one side emanates the nasty truth, while out of the other side issues the supposedly disingenuous advice for the police to act in self-defense. But I ask your honors and the people of the Philippines listening in today, how many times did you hear the former president state at the beginning of any address that he had a speech of 2 pages prepared, but to his regret, it didn't come from the heart? And then he would proceed to speak at length, sometimes for an hour or more, in his own uniquely colourful and crusty language, exposing his homespun theories on crime control, swearing a bit here, boasting a bit there, and generally delivering a speech more akin to Finnegan's Wake than a Gettysburg Address. That does not suggest crafty design, hinted at by Mr. Jeremy, quite the opposite. Mr. Jeremy's resort to the say one thing, mean another thing theory is complete supposition. It is not a legitimate argument because it implies that one cannot rely on anything coming out of Mr. Duterte's mouth, and that does not help the case for the prosecution at all. Well, that's about it for the speeches. I'll now turn to crimes against humanity and the contextual elements. And here I would like to start off by addressing the requirement that the acts of murder alleged be committed as part of or in themselves constitute a widespread or systematic attack. The second requirement is that these acts of murder be directed against the civilian population. With respect to the unique ICC requirement of an organizational policy, I would suggest that this concept has been conflated with the common plan, and as such, I shall address the matter later in my submissions. So, to start by reference to the widespread or systematic nature of the attack, I would like to draw your Honour's attention to the fact that Count 1 contains 9 incidents of murder in one city, Davao, hardly widespread. Ms. Robin Croft, in her submissions yesterday for the prosecution, Tuesday, told you that the widespread nature of Count 1 was evidenced by the multitude of bodies in a quarry, a mass grave. Well, the prosecution and the authorities in the Philippines have had years to continue its investigations since the judicial warrant was reimposed. I mean, they could have dug up the entire city of Davao, but all they have managed to produce, the prosecution on the matter, is a reference to Leila de Lima in a Senate committee where she talks about the discovery of a few human remains which could have belonged to World War II Japanese soldiers. The same goes for another witness's outlandish assertion that bodies were thrown into the sea off the coast of Davao. Well, the whole Gulf could have been dredged, but not one executed corpse has surfaced. As for counts 2 and 3, Ms. Croft showed us some maps with coloured dots to indicate the magnitude and geographical spread of what the prosecution alleges, without, of course, proving that they were extrajudicial killings not countenanced within the 49 incidents. Indeed, for this reason, there is nothing to link the charged incidents, those 49 incidents, to the wider picture. According to the appeals chamber, which confirmed a pre-trial chamber ruling on the matter in Bagbo, filing number 432 in the case record at paragraphs 35 to 36, any factual allegations outside the charged incidents, in this case masses of generically alleged extrajudicial killings, must be proved to the required standard. And for this, NGO reports, academic statistics, and media articles are, as a rule, considered insufficient. Ms. Croft also screened images taken from the Duterte administration's PDEA report for the years 2016 to 2019, if we can pull that up now, which cite figures of the number of deaths of drug personalities in anti-drug operations without proving that they were illegally murdered, but she neglected to contextualize these numbers by reference to other parts of the same report which show that in comparison to the number of arrests and operations conducted, the number of deaths are minimal. Please, if you will, show a bar chart that we have helpfully prepared with the figures and a pie chart with the percentages. So, if I may just conclude, the only thing that is widespread here, or rather spread wide, is the utility of the prosecution's statistics. Now, turning to the civilian population, or the target of the attack, let me say straight away that the prosecution case theory with respect to the definition of the targeted population is, to put it extremely politely, muddled. In layman's terms, the prosecution has hedged its bets by presenting 2 alternative propositions, hoping that this pre-trial chamber will settle for one of them. From paragraph 17 to paragraph 20, inclusive of its document containing the charges, the prosecution argues that Mr. Duterte launched an attack on the entire population of the Philippines, pursuant to a policy to neutralize persons perceived or alleged to be engaged in crime. In paragraph 21, however, this so-called attack is directed not against the civilian population at large, the whole population, but rather against a considerably smaller and nebulous margin of society, namely the alleged criminals themselves. Let us start by dealing with the first scenario, namely that the former president, whose loyalty and love for his country is and has always been beyond question, launched a wholesale attack on the whole population of the Philippines, on the entirety of his nation, including the very same people who put him into power. Such a suggestion is not just incomprehensible, it is quite bizarre. The reason for this rather strange assertion, so I submit, is grounded in the prosecution's latest brainstorm on the matter, which it set out last year in a brief appealing a decision of this very same pretrial chamber in the El Hishri case. And I do apologize in advance for the rather dull expose which will follow, but I do find it instructive to illustrate the chameleon-like nature of the prosecution's case theory. In this instance, Your Honours found that the civilian population attacked by El Hishri comprised prison detainees professing a certain political ideology. In so doing, Your Honours declined to issue an arrest warrant for El Hishri, where the victims of his crimes had been detained for totally unconnected and non-political reasons. Now, you might ask yourselves, why did the prosecution decide to appeal this decision? It was not as if it had been denied the arrest warrant for El Hishri that it had sought. Well, a key to the answer, so I believe, is to be found in the chronology of the events. On 10th February 2025, the prosecution rushed out its application for Mr. Duterte's arrest, believing that a unique opportunity to apprehend him had arisen. In this application, the prosecution defined the attack perpetrated by Mr. Rodrigo Duterte as being aimed at the entire population of the Philippines. Let us now fast forward to 10th July 2025. The pretrial chamber, this same pretrial chamber, ordered the arrest of Khalid al-Hishri for an attack on an objectively identifiable civilian population of detainees, while finding no justification to suspect him of crimes committed against a discrete subsector of that population, exhibiting characteristics distinct from those of the general population. Well, as you can guess, the prosecution didn't like that decision and hastened to appeal it. Not, I would suggest, out of any true concern for the purity of international humanitarian law, but rather because it put a spanner into the works of the Duterte case. That is, the only other active case that is his prosecuting before this court. After all, if we apply the resulting logic of Your Honour's decision in El Hishri to the prosecution's case theory in the Duterte case, at least as it stood as of 10 July 2025, then alleged drug pushers and alleged criminals would be deemed a separate, subjectively defined subgroup of the general Filipino civilian population, displaying different characteristics and, as a result, excluded as targets of the attack. So, 8 days passed between this decision of yours, Your Honours, and the notification of the confidential version of the prosecution's pre-confirmation brief on 18 July last year. And I'm prepared to wager that while beavering away with their attempt to appeal the El Hishri decision, the gurus on the top floor of the Office of the Prosecutor were also frantically discussing how to deal with this inconvenient fly in their conceptual ointment. They had to think of a way to accommodate this pretrial chamber's ruling while not compromising their appeal. So, lo and behold, and rather unsurprisingly, the pre-confirmation brief contained a new feature, namely the second scenario to which I referred earlier, that the target of the attack was not the Filipino as a whole, but the suspected drug pushers and criminals. Now, even if the former president did promulgate an organizational policy of eliminating suspected criminals and drug pushers, which he most definitely did not, this policy did not and could not constitute an attack directed against a clearly definable civilian population. Firstly, the segment of society victimized cannot be said to display objective characteristics distinguishing them from other members of society and thus rendering them susceptible to an attack. After all, how does one define a suspected drug pusher or suspected criminal for the purposes, let us say, of count one, where there were no HVTs or high-value targets or PRD lists or kill lists or what have you? It is not as if criminals have identifying features such as a shifty look or a 5 o'clock shadow or a sack marked swag. In other words, the definition suspected drug pusher or suspected criminal entails the exercise of discretion on the part of the perpetrator implementing the organizational policy. It is a shifting and mutable concept. It is a subjective determination. In our submission, there has to be, at the very least, an objectively discernible characteristic which unites the members of the targeted group such that they can be deemed a civilian population for the purposes of the attack. Leaving the determination of membership of a civilian population to the people who pulled the trigger introduces a degree of random selection, and as cited quite clearly in the Al-Hassan confirmation decision at paragraph 149, the prosecution must prove that the attack was not directed against a limited group of randomly selected persons. This ruling, Your Honours, was the expression of the law as it had stood for many years, ever since the decision authorizing an investigation in the Kenya situation, where at paragraph 81, the pretrial chamber defined a civilian population as a group sharing, and I quote, distinguishing features, and added as follows, and I quote again, the prosecutor will need to demonstrate to the standard of proof applicable that the attack was directed against the civilian population as a whole and not merely against randomly selected individuals. So let us ask ourselves whether the alleged attack in this case was directed at the population as a whole or at a subjectively defined subgroup of perceived or alleged criminal offenders. The minute the distinguishing features of the civilian population in question are defined through the application of subjective criteria, the targeting process becomes completely random. The targeted civilians are perceived criminals, but perceived to be so by whom? Is it not the case that one man's despicable criminal is another person's righteous saint? In fact, have we not heard from the civil society that many of the victims were not drug pushers or criminals, but innocent members of the local community? To me, and as a matter of logic, it would appear that the targeted population in the Duterte case was selected randomly. Even according to the prosecution's own witnesses, who talk about quotas of neutralization that had to be met, and their motives for target selection, which had frequently nothing to do with suspected criminality, but rather personal vendetta, or on one occasion, just because the victim had cheated at cards. With that, Madam President, Your Honours, I conclude the chapeau or contextual requirements of crimes against humanity. And I will now turn to the modes of liability or means of perpetration. Now, I have racked my brain for many a month pondering one question. If Rodrigo Duterte was so shamelessly brazen as to broadcast his murderous intent in public ever since he was the mayor of Davao, why did it take the ICC prosecution almost 4 years to open an investigation after Rodrigo Duterte pulled his country out of the International Criminal Court? After all, why did the ICC prosecution not just save itself all the hassle of its jurisdictional problem, a fundamental issue that still plagues it and remains to be resolved by the appeals chamber? We won't talk about that today, obviously. But why did the prosecution not seek to initiate its official investigation within the 1-year withdrawal period, especially given the fact that Mr. Karim Khan, the victim's representative embedded in the role of chief prosecutor, had received judicial authorization to interview at least one of the criminal cooperating witnesses substantiating the crimes of the Davao mayoral period? Well, for me at any rate, it didn't take too long for the penny to drop. As I mentioned in my opening statement, the prosecution knows that it is not enough simply to assert that Rodrigo Duterte said outrageous things and that deaths occurred, and so, as a result, he must be criminally responsible. There is a requirement for what is called a causal nexus. The prosecution has to show which one of Duterte's statements, orders, or commands were given to a specific individual who then went out and pulled the trigger or communicated the command to someone else who also went out and pulled the trigger, killing one of its 78 identified victims. That would have been the classical way to prove a causal link between stuff that came out of Rodrigo Duterte's mouth and the deaths pertinent to the case. That would have been ordering under Article 25(3)(b). But the prosecution cannot show such a causal link. They've never been able to do that. They show you a lovely pyramid. It's on the screen, with Duterte at the top, the co-perpetrators underneath, the DDS handlers underneath them, and the hitmen perpetrators at the very bottom. To quote Mr. Julian Nichols, how cute. But what the learned prosecutors can't show you is the connecting line between Duterte at the top and the next level down, comprising the so-called co-perpetrators. I hope Ms. Croft will forgive me for vandalizing her screenshot, but there you have it. That is where the apex slips off the pyramid of Giza. The most they can do is allege that their cooperating witnesses who pulled the trigger and whose credibility is about as worthless as a devalued peso understood that killing is what Duterte would have wanted, or that they had no choice but to comply because that was what was expected of them by their handlers. or other such similar expressions of a totally subjective sense of obligation. But as they know, not one of the 49 incidents mentioned in the document containing the charges manifests such a causal link between a speech, an order, and one of the charged incidents. I will state it for the record. In fact, I will state it a number of times during my submissions. There is no smoking gun in this case. And that is not for want of a desperate attempt to find one on the part of the prosecution, with all their leading questions when they interviewed their criminal cooperating witnesses. Not one witness relevant to any of the 49 incidents with which Mr. Rodrigo Duterte is charged will testify that he received a direct order from the former president to go out and kill someone. Let us just digest this. All those speeches where the former president made various threats to kill, but not one demonstrable incident set out in the prosecution's document containing the charges, which details an act of murder committed as a result of a direct order given by him. This, in and of itself, should be sufficient to convince any reasonable bystander observing the conduct of these proceedings that Rodrigo Duterte is innocent of these charges leveled at him. It is for this reason, and because of the complete lack of reliable cooperating witnesses, that the prosecution has alleged not one, but a plethora of theories as to the means of perpetration, to link the crimes allegedly committed to the person who is far removed from the incidents of murder and who has been targeted for prosecution. And I say targeted for prosecution. Normally, I would say that such a multiplicity of legal theories speaks to a lack of clarity and prosecutorial uncertainty. Indeed, some of these modes of liability, as pleaded, contradict each other as a matter of logic. Nonetheless, I would like to make the following general observation. As the defense has progressively reviewed the massive databases of evidence disclosed, it has become increasingly apparent that given the absence of direct evidence directly implicating Rodrigo Duterte or even indicating his participation in or control over any one of the 49 incidents alleged in the document containing the charges, the prosecution has resorted to papering over the cracks with human rights reports, press statements, hearsay, and of course, Mr. Duterte's bluster and political hyperbole. And where these documents are not suffice, the prosecution has resorted to the time-worn theory of indirect co-perpetration, Article 25(3)(a), of which the parameters I would respectfully submit are still subject to dispute. So I will now turn to this mode of liability, which is the principal mode of liability leveled at Rodrigo Duterte. As we all know, in order to prove criminal liability through indirect co-perpetration, there is a need to show a common plan upon which the suspect and his co-perpetrators, because you need co-perpetrators for indirect co-perpetration, a plan on which they mutually agreed. And that common plan must, without exception, have a criminal element. As I have already stated, the only plan in play was not just totally legitimate in nature, but was in addition wildly supported by the Filipino electorate, which ensured that Mayor Rodrigo Duterte's governance of Davao City throughout the years would thereafter put him into the Malacanang. According to the prosecution, the criminality of the common plan expressed itself as follows, and I quote from their documentation: an agreement to neutralize alleged criminals in the Philippines, including those associated with drugs, through violent crimes, including murder. Well, they really covered all options there. The existence of such a criminal plan is, of course, entirely preposterous, and, I should say, totally denied. I would suggest that the prosecution cannot point to any particular point in time where there is direct evidence indicating that even two of their so-called co-perpetrators actually met to agree to such a preposterous scheme. As such, the plan cannot be described as common to anyone. If anything, it's an artificial construct derived from the 10 assertions which are set out in paragraphs 24 to 33, inclusive of the prosecution's pre-confirmation brief, all of which comprise circumstantial evidence of the lowest quality, pointing to a mutually agreed design which exists in the prosecution's mind and nowhere else. Of course, there is nothing wrong with construing the existence of a common criminal plan from circumstantial data. But the cardinal rule of such a category of evidence is that the incriminating facts derived therefrom must be the only reasonable inference in the circumstances. What we can say with a degree of certainty, which reaches more than a substantial degree of certainty, is that no inference can be drawn from the comments of crime-based perpetrators. And to hammer the point home, I would like to screen you just a selection of excerpts taken from the interviews of a number of the prosecution's criminal cooperating witnesses. Or witnesses. Where are they? Number one. Interviewee: at least more or less than 10 buy-bust operations. Where somebody was shot, asked the interviewer. Yes, sir. Interviewer 1. Okay. And on those 10 occasions, was the shooting justified? Interviewee: yes, sir. Number 2. So, if he shot at us, we would also shoot back. But if he were to stab at us with a knife, then we wouldn't. We wouldn't shoot a person that was holding a knife. And the third one. Witnesses who said, the PNP never said kill those people. Another quote. From what I recall of the incidents that I was at, all of them had guns, and they were pointing them at the pusher-buyers, or they were pointing their guns at the pusher-buyers. At the operations I was at, I'm talking about the operations I was at, the reason that they were killed was because they were pointing their guns at us, or they were firing their guns at the pusher-buyers. That's from the prosecution's own witnesses. Now, let us analyze the other circumstances as set out in paragraphs 24 to 33, inclusive, to see whether a meeting of minds between co-perpetrators is indeed the only reasonable inference in the circumstances. The first indication, and that is that in the late 1980s, in other words, 20 years before the charges in this case, Mayor Duterte allegedly instructed civilian confidants and local police to neutralize. And I stress to neutralize and not to kill criminals. That's what's stated in the PCB. And that he provided weapons and funds for this purpose. Now, I would say that there is nothing untoward in providing policemen or civil volunteers with weapons to carry out their lawful duties. That's what happens in my country. The prosecution has not shown us how arming civilian volunteers is actually illegal. And the burden of proof rests on it. After all, one does not fight crime with kind words and gentle admonishments. The fact that these conscripted civilians understood the words to neutralize to mean to murder is not something for which Rodrigo Duterte must be held responsible. Trust me, had any one of the unreliable, insider, criminal cooperating witnesses substantiating the assertions made in paragraph 24 of the pre-confirmation brief said that Rodrigo Duterte gave a direct order to murder one of the 78 victims, the prosecution's lawyers would have written it into their charges, point blank. But they did not. And furthermore, any false allegation made by cooperating criminal witnesses made years before the charged incidents and without the time frame of the case does not constitute pattern or similar fact evidence indicating a predisposition to murder criminals. Accordingly, the allegations concerning the activities of the so-called Davao Dev Squad, formerly the so-called Lambada Boys, are irrelevant both to proving a criminal plan and that such a plan, more importantly, was common to any of the so-called co-perpetrators mentioned in the document containing the charges and released a few days before the confirmation hearing in a lesser redacted version of the PCB. Ronald De La Rosa, Bato, as the Chief of Philippine National Police, De La Rosa issued a pre-drafted command circular number 16 of 2016 on 1st of July of that year, formally launching the anti-illegal drugs campaign nationwide in express pursuance of Duterte's campaign promises. There is no dispute that CMC number 16 of 2016 mentions Project Double Barrel, which was indeed modelled after Davao City's policing strategy and was directed at the neutralization of illegal drug personalities nationwide. But here we come to the crux of the prosecution case. The manifestation of the criminal plan in writing. Neutralization as a euphemism for murder. Ms. Robin Croft certainly thought so when making her submission on behalf of the prosecution, highlighting the word in bright red and presenting us with a slide where the word neutralization forms an integral element of the common plan. To import an element of criminality into what would otherwise be a perfectly anodyne legal document, the prosecution resorts to relying on speeches and interviews given by Ronald De La Rosa, Bato, within a day or two of him being appointed the chief of Philippine National Police. For example, in an interview relied on by the prosecution at footnote 136 of the pre-confirmation brief, De La Rosa explains how tok hang means knock and plead, and that it is a totally legitimate police strategy. However, the citations relied on by the prosecution to infer that tok hang was a criminal modus operandi are completely taken out of context. I shall just cite one question and answer from the media interview on which the prosecution relies at paragraph 27 to prove that De La Rosa, when talking about instilling fear in the hearts of drug users, was actually proposing a policy which was anything but criminal and totally supportive of the main tenet of the defense, namely that the only use of force would be that envisaged by way of self-defense. And I quote, question, "Sir, you mentioned about instilling fear. When you instill fear, how do you ensure that you do not violate human rights?" Answer, good question. We will see to it that the police operational procedures are being followed in every legitimate police operations. When they see that the police are really determined to go for them legally, he stresses the word, and many of them go down, maybe they'll get scared. That's PHL OTP 000-16403 at page 13. In any event, what the prosecution has not told you, and what it has not shown you by way of its opulent images on the video screen, is that the supposed criminal blueprint set out in Command Circular 2016, number 16 of 2016, is totally negated by the content of the document itself. Let us take a look at paragraph 8E and F of the very same Command Circular, number 16 of 2016, which states quite clearly that all operations should strictly observe the rights of the accused enshrined in the Philippine Constitution, as well as international law and human rights. Why, I ask you, did Mr. Edward Jeremy, counsel for the prosecution, in his very eloquent and gilded address, not screen this part of the Command Circular? After all, this Command Circular, as elaborated by Ms. Robin Croft, was the very essence of his criminal common plan, in writing. This is the basis, so Mr. Jeremy stated, for the criminal agreement to kill high-value targets. And if that were not enough, the lawfulness of Command Circular 16 of 2016 was reiterated 3 weeks later on 22 July through the initiation and issuance of PNP Investigative Directive number 12 of 2016, which set out additional policies and guidelines in the conduct of double barrel. The document also included an exhortation to monitor human rights violations perpetrated by PNP operating units. The term neutralization itself is, of course, not defined anywhere in any of these documents as meaning to kill, a point the prosecution itself conceded at that moment in time when it was seeking the opening of an investigation. And I refer, Your Honours, to ICC 01 on 21, document number 7. So, the prosecution, throughout its pre-confirmation brief, invites this chamber to find, by inference, that neutralization means murder, and even carves it in stone as its formal statement of the common plan. But we, the defence, can show that the term neutralization can only mean the use of self-defence where officers' lives are endangered. For this, the text of the circular must be read in the context of the governing framework and other PNP directives. It is our submission that across the political, legislative, judicial and law enforcement contexts, the consistent articulation has always been that neutralization denotes lawful restraint. At the executive and operational level, the Chief of the Philippine National Police, Ronald de la Rosa, Bato, publicly clarified in 2017 that neutralization means arrest. Furthermore, in an official transcript dated 28 October 2024, the former Chief of Police, de la Rosa, testifying before the Committee on Accountability of Public Offices and Investigations, testified that the term neutralization was anchored in the PNP Operational Procedures Manual, where it is specifically and strictly defined. Let us just have a look at what he said. And for your ease of reference, we will also display the said passage in the PNP Operational Procedural Manual to which De La Rosa referred, which incidentally was published in 2021. Neutralization, and I quote, "A police intervention in strict accord with the use of force continuum and/or principle of proportionality on the use of force purposely to contain or stop the unlawful aggression of the offender. This may include an arrest, capture, surrender, or other acts to subdue the suspect." It strikes us as rather mind-boggling that the prosecution should have failed to appreciate the significance of this. It was aware of De La Rosa's speech because they disclosed it to us. But the prosecution's investigators clearly never bothered to read the procedural manual to which De La Rosa was referring. In fact, we know that they didn't, because it's not on their list of evidence. Within the judicial sphere, when the terminology was examined before the Supreme Court of the Philippines, in petitions challenging aspects of the anti-drug campaign, the government defended the circulars on the basis that they did not confer a license to kill. The Supreme Court of the Philippines, however, to date, has declined to issue any ruling declaring the campaign unconstitutional, has declined to invalidate circulars, and has declined to rule to date that neutralize or neutralization means to kill. The Supreme Court's treatment of the issue is particularly instructive. The Court observed that the wording was neither novel nor introduced during the Duterte administration. It had already appeared, for example, in the 2014 revised PNP manual on anti-illegal drugs operations and investigation. In other words, the term formed part of the existing police vocabulary. The Court further clarified that the mere inclusion of the term in a circular does not render that instrument unconstitutional, especially where the circular expressly mandates compliance with internationally accepted legal principles, public policy, and the full observance of human rights, as we showed you earlier. No circular has been invalidated on this basis, nor has it ever been established at the highest level of domestic judiciary that to neutralize means to kill. The judicial record does not sustain such an equation. In each institutional setting, therefore, the term has been situated within ordinary policing powers and constrained by the lawful use of force framework. The testimonies of those operating within that framework, the prosecution's witnesses no less, are aligned with this documentary record. For example, witnesses P1158 and P1170 explained that neutralize means to arrest or to incarcerate through legal means. It did not mean to kill. Witnesses P1050 and P1174 confirmed that lethal force arose only where a suspect's resistance placed an officer's life at risk, reflecting the ordinary doctrine of self-defense and consistent with Mr. Duterte's repeated public declarations that force was justified only in such circumstances. P1214 further indicates that operational decisions were made by officers on the ground within established protocols. So,
Maître, je suis désolée de vous en...
I'm sorry to interrupt, counsel, but once again, you need to be specific and provide the document reference number. You must specify the document number, the reference number for us.
if I may, Madam President,
Merci beaucoup,
of course,
Thank you very much.
I thought we had an understanding with the Learned Chamber's legal officers that we would be able to provide references after the hearing. But of course, the document that I was referring to is PHL OTP 00090518-R01. So, Madam President, Your Honours, taken together, the manual, the public clarifications by police leadership, the state's position before the highest court in the Philippines, and even the prosecution's own corroborative witness testimony, all of this material demonstrates a coherent and consistent understanding that neutralization was articulated as lawful incapacitation through arrest and related measures, not as a policy of killing. And if the prosecution's case for the common plan in counts 2 and 3 is based on Command Circular number 16 of 2016, we might as well pack up and go home because Mr. Duterte is simply not guilty. However, for the sake of completeness, I continue. The fifth indicator of a common criminal plan, as alleged by the prosecution in paragraph 28 of the pre-confirmation brief, appears to be the concerted broadcasting of inflammatory speech. Here the prosecution once again selectively cites excerpts from 2016 media interviews with Ronald De La Rosa, Bato, and Vitaliano Aguirre, which suit its purpose and case theory, while totally ignoring the more unequivocal comments in those interviews which destroy its case. Regarding the interview with De La Rosa, mentioned in paragraph 28, after supposedly inciting a crowd of drug addicts to cause criminal damage to the properties of their narcotics suppliers, the newly elected chief of police states, "It's either you will die from police gunfire," and he adds, "if you resist." That's PHL OTP 0000849, page 2. Likewise, with the comments in an Al Jazeera interview, PHL OTP 00090340, comments attributed to Aguirre, from which the prosecution imputes criminality to Rodrigo Duterte by citing Aguirre's comment that the administration's policy was to stop crime and kill drug lords. Such throwaway comments reflect on Aguirre alone. And God forbid we're not alleging that Aguirre did anything wrong. Especially when, in the very same Al Jazeera interview, Aguirre states, not once, but twice, that the policy of Duterte himself was for the police to use lethal force only in self-defense. We can display that on the screen, and the part that I want to read is highlighted. And President Duterte was very clear on this matter, he said, Aguirre, that there will be no killing of unarmed offenders, meaning to say that you use force only when your life is in danger. Later on, in the very same interview, Aguirre would repeat the same theme which exculpates Mr. Duterte, PHL OTP 00090340 at page 4. And I read out the relevant passage which is highlighted once again. They are supposed to arrest them, but when they fight back, then the president has instructed them that they must first protect themselves. So much for Mr. Jeremy's elastic mouth theory. Even he thought that Duterte's speech was bifurcated, and even if he did think so, his so-called perpetrators did not. So why does the prosecution cite the excerpts which support its case so selectively? Well, I'm not going to impute any malfeasance, but I can hazard a wild guess. I would suggest that the people reviewing the prosecution's massive databases for suitable evidence are performing keyword searches. Most likely, some of the most utilized operands were the words kill and perhaps sometimes neutralization or neutralize. Once the member of the prosecutor's staff has his hit, he excises the excerpt, rejoices that he can slot it into the predetermined case theory, and does not bother to read the rest of the item of the evidence, where the exonerating evidence is unequivocal. Turning to the sixth indicator of the supposed criminal plan, as set out in paragraph 29 of the pre-confirmation brief. None of the speeches imputed to the former president, nor the use of what the prosecution calls dehumanizing language, dehumanizing language by the alleged co-perpetrators suggests criminality. I would suggest that it is within the bounds of acceptable, albeit extreme political discourse, to refer to drug users in such a way as beasts, animals, or to the barangays as being plagued by the drug menace. Well, the last one is true. You can hardly expect populist politicians and law enforcement officers to refer to drug pushers and criminals as upstanding pillars of the local community. I really do feel that the prosecution is at a loss if this is its circumstantial evidence for proving the existence of a common criminal plan. The same goes for the seventh supposed indicator of criminality, which is based on the names created for the two police operations, Double Barrel and Tokhang, along with their supposed evocation of firearms metaphors. While the source for this particular gem, witness P1207, a self-confessed murderous villain, might have guns perpetually on his mind and insert their imagery into his daily speech, it does not mean that those who formulated the anti-drugs policy were acting under a similar caprice when they devised the nomenclature for these two particular police operations. And of course, there were other police operations with completely different imagery, such as the one-time, big-time operation referred to by a few prosecution witnesses, and the riding in tandem operation. The mind can only boggle as to what type of nefarious imagery the prosecution believes that last title evokes. None of the indicators I have mentioned up until now have shown in any way a mutual meeting of minds between alleged co-perpetrators, evincing a communality of purpose or an agreement to act in an illegal fashion. Of course, the prosecution has shown us pictures of the alleged co-perpetrators uttering comments similar to those issuing from Rodrigo Duterte. But this does not indicate a meeting of minds, as I will elaborate shortly. The eighth factor purportedly evincing a plan of agreed criminality, is set out. The prosecution relies on what it believes to be the Duterte's administration's unabashed publication of statistics recording the number of deaths occasioned in the context of the so-called war on drugs. But let us just look at how and where the statistics relied upon were being published. In two government reports, the first of which being the Duterte administration's year-end report for 2017, totaling 63 pages, covering every sector of government and the economy, and of which just 2 pages are devoted to policing activities. We can give you the document ID number shortly. It's on the screen. While the deaths of 3,967 drug personalities mentioned are indeed recorded, as Ms. Robin Croft so helpfully pointed out in her presentation, and are not insubstantial, these deaths comprise a fraction of the 118,287 total arrests for drug-related activities, especially when the government is conducting special operations in a concerted drive to curb the narcotics problem. Such statistics are certainly not indicative of a wholesale policy of murder designed to supplant the process of law. If they were, then certain Latin American state parties would have regularly equaled or exceeded the Philippines in the number of law enforcement killings per capita of the population. What is quite egregious, however, regarding the prosecution's reliance on the 2017 Key Achievement Report is the way in which it glosses over, or rather ignores, those pages which do not suit its case theory. Take, for example, pages 28 of the document, which highlights the fact that 1,900 drug-related investigations had been carried out against law enforcement officers in the preceding year, with 375 police officers being dismissed, including the 2 policemen involved in the murder of Carl Arnaiz, who were later convicted and sentenced to life imprisonment. These policemen were affiliated with the Caloocan City Police Station, and where, so the report mentions, 1,000 personnel belonging to that station were sent for retraining. To conclude, this document, far from being evidence of a conspiracy hatched between co-perpetrators, is in fact a testament to the Duterte administration's respect for the rule of law and written proof of its intolerance for rotten apple police officers. As for the second official publication, which is supposed to substantiate the criminal plan, we turn to the 2016 annual report issued by the Philippine National Police. The statistics are quoted, with all respect, in a misleading fashion. The tables used by De La Rosa, and particularly the pie chart, show a remarkably low incidence of deaths in comparison to arrests and voluntary surrenders. Obviously, the misleading aspect of that is the prosecution's representation of the statistics, not De La Rosa's. So, coming to the 10th and final source of circumstantial evidence, supposedly supporting the mutually agreed nature of the criminal plan. And this is the fact that the extrajudicial killings, to quote the prosecution's words, followed the same patterns and modus operandi, with the perpetrators covering their tracks. But here, let me ask a question which begs an answer. If the Duterte administration was so barefaced as to openly declare its intent to kill drug users and pushers and celebrate this, as the prosecution argues, in official governmental publications, why would it encourage the perpetrators to go to such lengths to disguise such an intent? I mean, of course, anything's possible. But I'm just pointing out the internal contradiction in the prosecution's case theory. In any event, as they say in English, there is more than one way to skin a cat. And the differing types of modus operandi that we have encountered in the prosecution's 49 incidents of murder involve all conceivable modes of butchery, ranging from strangulation, suffocation, to stabbing and shooting. Now, assuming that the prosecution can overcome the hurdle of proving the existence of a common criminal plan, how has it shown that the so-called co-perpetrators coordinated between themselves to reach a mutual agreement to execute it? Well, it hasn't. All it can do is show a selection of comments made by Mr. Duterte's closest colleagues in government, and all of which take their rhetorical cue from him. The prosecution then artificially defines the intended individuals, the identified individuals, as a collective of co-perpetrators. Now, common law jurisdictions, such as the one I come from, are familiar with these issues in the context of the law of conspiracy. The federal rules in the United States, for example, allow the statements of co-perpetrators to be used as circumstantial evidence, one against the other, to establish the existence of a conspiracy, but require that these statements be made during and in furtherance thereof. Narrative venting, which is what all these supposed co-perpetrators did, the ones identified by the prosecution, does not further the criminal objective. In furtherance thereof means that the statement relied on must advance the objectives of the conspiracy, such as through reassurances, updates, or actions taken to avoid detection. Now, I do realize, Your Honours, that there isn't too much jurisprudence on this matter, but let us look at it logically. Where can one really draw the line if it is sufficient to infer a mutual agreement to execute a criminal plan if we rely only on the statements of the people in the vicinity of a criminally verbose suspect because of the same quality of verbosity it alleges? This is what could be called bootstrapping logic. Building on limited information with the very same information in an attempt to validate that information or to create a structure there without. Put simply, the prosecution has advanced its cart before its horse. It has merely selected a number of individuals working alongside the former president who made similarly offensive comments and has then called them co-perpetrators. Instead of seeking evidence which might shed light on the interactions of these individuals between one and another, and construing a criminal conspiracy therefrom, should the evidence even support such a hypothesis, the prosecution has taken its preconceived and predetermined premise of a criminal plan and forcibly superimposed it on these individuals. The artifice of the prosecution's working methodology in conjuring up this criminal collusion becomes even more apparent if we examine the evidence emanating from the crime-based perpetrators themselves on a granular level, especially from the prosecution's own star witnesses, three of whom supposedly formed the hardcore of a more limited organization referred to earlier in my submissions. I'm trying to comply with redactions. P1, for example, a self-confessed murderer whose recruitment by the prosecution will be examined elsewhere, was asked about the common criminal plan of his associates up to 2017. And this is what he had to say. Every time somebody was at fault against the government of Rodrigo Duterte, we didn't bother to send them to prison. We would just kill them. That's PHL OTP 0001-2584 at lines 248 to 250. Okay, and that was the audio which I just quoted, and here we have the transcript. PHL OTP 0001-2376 hyphen R02, lines 248 to 250. So, having given you that quote from P1, I would say that as far as this witness was concerned, the common plan was not a refined policy of cleaning up the streets, but rather a killing frenzy of the political opposition. Obviously, no such policy existed, and no such policy is alleged. P3, whose evidence relates to the presidential period, describes a similar orgy of killing without rhyme and without reason, but not drug addicts, nor alleged criminals, under a clear criminal direction to target drug users for murder, criminals for murder, when he states that on occasion he would perform so-called clean arrests. Prosecution's witness, P3, is not clear when he's actually following their supposed criminal theory or when he's is. What are clean arrests? These are arrests subsequent to which the apprehended criminal would be handed over for a judicial process. And so with that, I believe, I have exhausted the first limb of the objective requirement for indirect co-perpetration and have shown conclusively that there was no mutually agreed common criminal plan. Madam President, there are 10 minutes to go. I will start with the concept of essential contribution, which is indeed the second limb that I want to talk about with respect to this mode of liability, which requires the prosecution to show objectively that Mr. Duterte himself made an essential contribution to the furtherance of this scheme of criminality, and what is more, that subjectively he was aware that he was making such a contribution. This is what us Latin-speaking lawyers, would call the sine qua non test. Or to put it another way, did these 49 murders, which the prosecution has identified, occur specifically because of Rodrigo Duterte's involvement? Or, to make the logic a whole lot simpler, would Rodrigo Duterte's withdrawal from this criminal scheme to target suspected criminals, as alleged by the prosecution, have led to the avoidance of these 78 deaths? Let us see where this test is set out in the Ali Koshaib trial judgment. Paragraph 796. And I'm going to quote the essential part for the purpose of the essential contribution. The accused must make an essential contribution without which the commission of the offence would not be possible. To hold an accused liable as a co-perpetrator under Article 25(3)(a) of the statute, it has to be established inter alia that he or she had control over the crime by virtue of his or her essential contribution to it and the resulting power to frustrate its commission. Well, here I would like to show you the statistics pertaining to the rate of killings since the former president has left power and the responsibility for law and order has passed into the hands of President Ferdinand Marcos Jr. I rely on a report published by academics at the Third World Studies Center in the University of the Philippines in the context of what is called the Dahas Project. And trust me, the authors of this report, comprising weekly statistics on the first year of the Marcos administration from 2022 to 2023, are no great friends of the former president, Mr. Duterte. This report was even cited, I remember, in a Rappler article, but it's to be found on our list of evidence at PHL D36 0006-0001, pages 0006 to 0010. The report for the first year of the Marcos administration showed that out of 342 killings, 160 were at the hands of state agents. And the figures and the statistics just kept on rising, with the second year of the Marcos administration, 2023 to 2024, showing an increase in deaths at the hands of vigilantes, albeit a decrease in deaths at the hands of law enforcement officers, from 46.8% to 34%. Hardly a statistic to be proud of. So, with all the prosecution's fancy bar charts, I'm pretty sure that if they were to recreate them for the period of 2 years after Duterte left power, they wouldn't have room left on their computer screen. The numbers would be so sky high. The conclusion is that there is no reason to believe that Duterte's disappearance from the political scene would have frustrated the ongoing incidents of murder at the hands of state agents or vigilantes. Clearly, I'm forced to ask myself whether anyone on the other side of this room has thought of investigating the Marcos regime and the related phenomenon and holding someone accountable. Why are my colleagues sitting to their right, the victims' representatives, not clamoring for accountability for those deaths? Or is it of no consequence now that Mr. Duterte is sitting in the ICC detention center? As you can see, we have a number of yellow post-its on our table here. These are the document identification numbers of all the matters that I'll be talking about. But since we only have until 3 and until 1 hour tomorrow morning, I can provide the ID number if necessary, but I will move on, and we promise to give the Chamber at the conclusion of the hearing the full ID numbers of everything that I've talked about. And if the prosecution obviously wants something as well, he can...
Afternoon, Madam President. I would just ask my friend if he can read out the tab numbers, because every item per the Chamber's instruction has a tab number. So even if my friend doesn't read out the entire ERN of the page he's citing, the lines, if he gives us a tab number, at least we can check his homework in real time.
Merci beaucoup.
Thank you very much. Counsel, are you in agreement with this position taken by the prosecution? Well, the representative of the OTP. Mr. Kaufman, yes, ma'am. Judge Motik, please proceed.
Your Honours, I now come to ask myself another question concerning the nature of a common plan theory which applies equally to its subjective requirements. Has the prosecution shown substantial grounds to believe that Rodrigo Duterte's implementation of its fantasy criminal scheme was of such a nature that the murders detailed in its 49 charged incidents would have ensued as a virtual certainty in the ordinary course of events, and that he foresaw that they would occur as a virtual certainty in the normal course of events? Let us take a moment so that I can assure you that these wonderful words, virtual certainty, actually do exist in the court's case precedent and are not a fiction of my own. If you will, please display the first of 2 citations from the Abdul Rahman, otherwise known as the Ali Kushaib trial judgment from 2025. First of all, paragraph 795. While the common plan between individuals need not be specifically directed at the commission of a crime, it must nevertheless involve a critical element of criminality, meaning that in the context of the specificities of the case, it was virtually certain that the implementation of the common plan would lead to the commission of crimes. We can have a look at paragraph 706, and it talks about the general knowledge requirements, which I am sure Your Honours are very familiar with. So, with respect to the question whether the common plan entailed the occurrence of murders as a virtual certainty, the answer is an emphatic and resounding no. First of all, let us recall what the prosecution defines as the former president's list of high-value targets, what the media calls the kill list, and what one of Mr. Edward Jeremy's quoted witnesses referred to as the dead list. The number of individuals on this so-called kill list, the very list on which the prosecution relies to show that the knowledge that death would ensue, is 4,000 817. Those who are actually neutralized dwarfs in comparison and stands at 248. So, assuming that neutralized actually means killed, which it does not, then there is no virtual certainty attributable to Rodrigo Duterte that death would ensue from this kill list. Rather, a 5% chance. Let us have a look at a bar chart for exactly the same figures used by the prosecution as distributed geographically. I now turn to the issue of control, as it did or did not manifest itself in the crime base. In other words, can it safely be argued that substantial grounds exist to believe that Mr. Duterte's supposed diktat filtered its way down from his mouth and via his co-perpetrators to those who were supposedly going about committing these murders? How has the prosecution shown the concept of automatic compliance, or even virtually automatic compliance, so essential to its pyramidal structure? Well, by and large, and judging from Ms. Robin Croft's submissions, it would appear that the concept of automatic compliance is substantiated by reference to subjective comments made by perpetrators who talk about their will being controlled. For example, transcript, page 37, line 7 onwards. I felt like that I didn't have any choice but to follow their orders. It wasn't possible not to obey his commands. Another example, transcript, page 38, line 17. Co-perpetrators controlled the will of the physical perpetrators. End quote. According to the prosecution, members of the Davao Death Squad had to seek clearance from Mr. Duterte to conduct killings in Davao City. For this wild assertion, the prosecution relies once again on the evidence of criminals it has recruited, all of whom are inherently unreliable because of their being self-confessed vicious murderers, testifying in return for virtual immunity from proceedings at the ICC. We shall analyse the testimonies emanating from these individuals in detail later in my submissions. Now I can see Mr. Nichols scribbling away there, but I shall be referring to what are called statements of limited use. As for the other modes of liability charged, ordering under Article 25(3)(b and Article 25(3)(c), aiding and abetting, as I have said, no smoking gun, no evidence of a direct order, solicitation or inducement with respect to any one of the 49 incidents. No documentary record exists of a presidential order. So how could these orders have been transmitted for the purposes of Article 25(3)(b)? Well, unless Mr. Nichols envisages mental telepathy, I think that we can discount ordering. The prosecution has failed to elaborate in its oral submissions what it means truly by soliciting. If it means the ambiguous public speeches, then it is difficult to reconcile the frequent exhortations to self-defense with soliciting, unless, of course, you accept that Mr. Duterte super craftily inserted these exonerating comments into his speeches in order to craft himself a defense when the day of reckoning would come. As the prosecution asserts, speaking with a forked tongue, sometimes speaking his mind, sometimes saying what he wants you, your honours, to hear. Furthermore, generalised statements months before specific incidents do not establish causation or instruction. For aiding and abetting, there is no reliable evidence that Mr. Duterte provided practical assistance, encouragement, or moral support that substantially affected the commission of a crime, with knowledge of the perpetrator's intent. And finally, on modes of perpetration, modes of liability, I would beg you not to take heed of Ms. Paulina Masseter's assertion that Rodrigo Duterte failed to prevent or punish. The prosecution has not charged command responsibility under Article 28. And the reasons for that are clear. It is the same reason why it cannot prove ordering. There is no ascertainable chain of command descending from Duterte at the top via the co-perpetrators, so-called co-perpetrators, all the way down to the crime base. As I said, it all breaks down at the level of the co-perpetrators. And I would ask you very respectfully not to exercise your discretion to requalify pursuant to Regulation 55 of the regulations of the court. But if you do, and you shouldn't, I respectfully submit, you should order the prosecution to resubmit its document containing the charges and its pre-confirmation brief as amended, and to release Mr. Duterte in the interim. Now, I have finished that section of my submission, and I will now turn to the witnesses themselves, and I will be very careful not to mention anything that I'm not meant to. And I will discuss, first of all, the general reliability. A genuine criminal investigation is meant to be directed at establishing the truth. It is meant to elicit facts in an impartial manner and not to present witnesses with a preconceived idea and to seek confirmation thereof, whether it be by way of leading questions or anything else. By this, I mean that the golden thread linking practically every one of the interviews of the prosecution's so-called insider witnesses, who are, for the most part, ruthless criminals, is the a priori targeting of Rodrigo Duterte. In my submission, no real attempt was made to perform this duty of examining exonerating circumstances, or even to establish the existence of other actors who might be responsible for the high incidence of deaths in the context of the war on drugs. Most prosecutors will collate the evidence and thereafter analyse it and decide whether to prosecute with a view to obtaining a reasonable prospect of conviction, which is indeed the standard supposedly applied since Mr. Karim Khan assumed the role of chief prosecutor. A prosecutor is not meant to choose his target in advance and then find the evidence to support a preconceived desire. Now, I'm not going to engage upon a wholesale forensic analysis of the credibility of each and every witness. I am long enough in the tooth to appreciate that issues of credibility and weight are not normally litigated at confirmation, but are left to trial. This case, however, is unique. And as I have said, the prosecution's star witnesses are self-confessed murderers. And most of their statements were taken by the prosecution's investigators with the assurance of limited use. Namely, that anything self-incriminating would not be used against them in proceedings at the ICC. Although Mr. Nichols will undoubtedly tell you that these agreements of limited use are not to be understood as the grant of immunity from prosecution, for all intents and purposes, they are. And I am prepared to wager that we will not see even one, not one, of these incriminating witnesses in a dock at this court, nor in a dock at any court anywhere in the world, after they have been rehoused and given protection at considerable expense to the state parties funding this court. I do not think that I would be alone either in believing that there is something morally repugnant or even questionable from a public policy standpoint to shield not only one, but a number of murderers from prosecution at the ICC just in an attempt to nail Rodrigo Duterte. Indeed, in many common law jurisdictions, the use of a self-avowed murderer to convict an alleged murderer would normally entail vetting and scrutiny of the highest order. Those words, if I'm not mistaken, come from the Crown Prosecution Service's instruction manual. Public source. In fact, I would suggest that it would normally only be approved, firstly, when it is considered of more value to have a suspected person as a witness than as a possible accused. Secondly, whether obtaining the conviction of an alleged murderer is more important than the release of a self-confessed murderer. And finally, whether it is likely that a conviction could be obtained without the cooperation of the self-confessed murderer, or a number of them. Even after this vetting process, most courts and common law jurisdictions require an evidentiary supplement before relying on the sole testimony of a cooperating criminal witness, or what is otherwise called an accomplice witness. Such an evidentiary supplement, in legal parlance, is called corroboration, and rules exist governing what may be deemed suitable corroboration. I'm pretty sure that these considerations were never considered by the prosecution, for one very simple reason. At least two of the most prominent accomplice witnesses were offered up to the prosecution on a silver platter, and I cannot say by who in open session. Neither the Rome Statute nor its accompanying texts regulate the way statements of limited use are employed. I would like the pretrial chamber to consider the way academics and the prosecution itself has qualified the implementation of limited use statements in the past. And I quote from paragraph 49, which is open source, of a chapter on the Office of the Prosecutor in the 2022 edition of the Max Planck Encyclopedia of International Law, written by no less than Judge Betty Hohler of this court. And I quote, "One of the agreements the OTP may enter into during the investigation is an agreement with a person suspected of committing crimes within the jurisdiction of the court, is to provide a statement of limited use. The idea is that the person provides the Office of the Prosecutor with an oral or written statement for the purpose of pursuing leads or developing additional information or evidence on the condition that the statement will not be used against the interviewed person except as stipulated in the agreement. The purpose of such agreements is to ensure cooperation of so-called insider witnesses whom the OTP does not intend to prosecute, but are expected to provide key information or evidence against other, usually more senior suspects. Judge Höhler was effectively relying on footnote 20 to the prosecution's own filing, number 1118, in the Bemba Article 70 case, which states the same thing. Both sources stress that limited use statements should be used as a rule to pursue leads or to develop information, but not apparently, outright at any rate, to serve as the key and main testimony against a suspect. In my opinion, there is a good reason for this, and it is contained in the wording of Article 54, 3d of the Rome Statute, which is cited as the statutory basis for limited use statements. The prosecutor is entitled to enter into such agreements granting limited use on condition that the agreement would not be inconsistent with the statute. And I stress those words, not inconsistent with the statute. Using the evidence of self-confessed murderers to obtain leads or develop evidence from other sources, I would suggest, is consistent with the statute, as mentioned by Judge Betty Höhler. To give a get-out-of-jail card, however, to a whole bunch of murderers in order to fix liability to another, albeit pre-selected individual, also selected of murder, is, in my opinion, totally and wholly inconsistent with the object and purpose of the Rome Statute, which, according to its preamble, oft cited by the victims and the prosecution, is dedicated to the eradication of impunity. In my opinion, granting immunity to a murder suspect for core international crimes would be seen as undermining the object and purpose of the Rome Statute. Accordingly, I would ask the Chamber to find the statements of those witnesses afforded such limited use and to be of negligible evidentiary weight. Another issue pertaining to the general credibility of the prosecution's witnesses is the way in which they were recruited. In my opening remarks a couple of days ago, I talked about the general fairness of pursuing charges brought by a prosecutor who was formerly a representative for more than 100 victims of Mr. Duterte's alleged crimes. I also talked about a recorded telephone conversation in which one of the participants bragged about acting as President Marcos Jr.'s silent partner for channeling witnesses to the ICC. Apparently, I raised the presidential spokesperson's hackles considerably, So let me quote a bit more so that I can assure her that my cognitive faculties, which she doubted, are in fact intact. And this is what this covertly recorded individual, who I'm forbidden from naming, said. They cooperate through me, since I don't hold a position, redacted. But we are able to do it. So what? What happened here is an ICC investigator will give me a list of witnesses, documents they need to bolster the case against Duterte, then I provide it. I give it to the different agencies so it can be approved. There are witnesses who need a pardon. I get the authority from the President, and they are granted a pardon. Basically, like that, it becomes a priority mission of the government. I don't think I've disclosed here, Madam President, any working methodology of the Office of the Prosecutor. So now I turn to the incidents themselves, the 49 incidents. The prosecution invites you to view these incidents as the manifestation of a much larger pattern. To quote the prosecution's very words in filing number 330 at paragraph 5, the 49 incidents are a non-exhaustive list of examples of the conduct underlying the charges. Indeed, the prosecution speaks of thousands of victims in toto, data sets, and patterns of violence. Now, the defense does not deny that much drug-related violence did occur. It was occurring before Mr. Duterte assumed the reins of power and continued, as we have shown, by way of a sharp increase after he left office. But these grandiose visions of the prosecution are of no avail if the core criminality and incidents alleged in its document containing the charges are not made out. So the question before you is whether there are substantial grounds to believe, firstly, that each of these specific incidents were unlawful killings, namely deliberate acts of murder, and secondly, that they were knowingly committed to further the criminal objective of the so-called common plan or the state organizational policy with which it has been conflated. And finally, that they are indeed attributable to Mr. Duterte under a recognized mode of liability. Preempting a possible defense, always a good tactic for a prosecutor, unsure of the strength of his own case, there is a heavy reliance on expert analysis of data sets to argue that reported instances of self-defense were statistically improbable. Let me stress that it is the defense's view that if the contextual case depends on the scale of victims, namely thousands, as alleged by the prosecution, then establishing the evidentiary integrity of each charged incident is imperative. In other words, the defense firmly submits that the pretrial chamber should not commit any one of the 49 incidents to trial unless it concludes that there are substantial grounds to believe that Mr. Duterte's criminal linkage and liability has been established for each one. When these 49 incidents are disaggregated and examined one by one, as the statute requires, we submit, what becomes apparent is not the cumulative strength, rather the recurrence of certain symptoms of inherent weakness in the evidence. These weaknesses fall into 6 broad categories. The first is the over-heavy reliance on the testimony of cooperating witnesses who are inherent criminals with an inherent propensity to be unreliable and whose statements, as I mentioned, are not corroborated by external evidence. The second, hearsay attribution, or in less legal parlance, incriminating statements heard from a source twice or even 3 times removed. The third weakness, which infects the evidence, is the fact that some of the victims are unidentified, making it virtually impossible for the defence to pursue its own lines of inquiry. This weakness affects at least 9 out of the 49 incidents. The fourth weakness, documentary records, such as police and forensic reports, are at variance with and are contradicted by testimony of a single prosecution witness. Fifth, the hoary old chestnut of conflicting statements emanating from 2 or more witnesses testifying to the same event, some contradicting one another, some contradicting even themselves. And finally, the 6th weakness being the repeated absence of any evidence to link the hitmen to our client, despite the prosecution's best efforts to chivvy such linkage out of them. The defence will now show how these identified weaknesses reduce below the substantial grounds threshold the evidence for these incidents in the 3 counts as they appear in the document containing the charges. Count 1, the alleged murders during the mayoral period. Count 2, alleged murders of HVTs, the high-value targets, during the presidential period. And count 3, barangay clearance operations also during the presidential period. So I shall start with count 1. As we know, the first cluster of incidents falling under count 1 concerns the so-called and totally fictitious Davao Death Squad period. This concerns incidents 1 through 9 of the document containing the charges. The prosecution's attribution theory here is straightforward, that Rodrigo Duterte, as mayor, authorized killings through intermediaries. But when the evidence for this count is examined, as I've already mentioned, not one witness can say that he heard the mayor give an order to kill. The attribution of criminality to Mr. Duterte arises, for the most part, out of assumption layered on top of hearsay and follows a repetitive pattern which would, as a rule, entail the same mechanism of attribution. Namely, a hitman witness for the prosecution would state that his handler said that clearance came from, and I quote, above. But what does the word above mean? It means an unnamed superior and nothing more. The mode of liability imputed to Mr. Duterte, namely indirect perpetration, requires the prosecution to establish a stable chain of command through which the common enterprise filtered. If there indeed existed a structured approval process, as the prosecution alleges, one would expect operational consistency, not variability. The incidents contained in count 1 are also marked by internal inconsistencies which cannot be reconciled and which are indicative of the fragility of the prosecution's overall case. Incident number 1, for example, is based on the evidence of 2 witnesses who contradict each other on fundamental and materially crucial issues. Let me explain in more detail. P26, who presents himself as a participant, claims that Mr. Duterte telephoned a redacted third party to order the operation and was told that it was the mayor on the phone. Was told that the mayor was on the phone. Pure hearsay. The prosecution seeks to reinforce this through P2. Yet P2 was not present at the time. He was inactive, for reasons I can't mention, and relies entirely on what he heard from the redacted third party and another individual at a later date. P2's account is therefore pure, unadulterated hearsay. More significantly, it diverges from P26's version on fundamental points. The year of the incident, 2014 and not 2013. The number of victims, 2 rather than 3. The identity of the perpetrators. The channel through which alleged clearance was conveyed, via driver and bodyguard, to a different DDS member rather than through redacted. And if that is not enough, the method of killing, strangulation rather than stabbing, these aren't minor inconsistencies. They concern the core factual matrix. If the pre-trial chamber is unable to determine even these basic circumstances which establish opportunity, method, since the prosecution made such a big deal out of incident 3 on Monday and screened the video of the hit job itself. If you recall, the one in a marketplace which was supposedly viewed with approval by our client, I would like to devote a few words to it. If your honours follow the transcript that accompanies this video viewing session, the prosecution fixated on the comments of Mr. Duterte telling the person operating the video not to zoom in